Good afternoon, everyone. This is Nitya Nagarajan, a partner in Husch Blackwell's International Trade and Supply Chain Group. I specialize in advising clients on handling trade remedies actions such as anti-dumping and countervailing duties, Section 232 and Section 301, as well as customs advisory services. Prior to entering private practice, I worked at the Department of Commerce, which is the agency primarily involved in handling trade remedy actions. We're excited to be talking with you today about foreign adversary bulk power equipment restrictions and the new Section 232 transformer investigations. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I'd like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your question via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, we will be answering them later via email. We truly appreciate audience participation and encourage you to submit questions. There is also an icon to assist you with your viewing preferences. Accordingly, please note that you can expand your slide area by clicking on the maximize icon on the top right of the slide area or by dragging the bottom right corner of the slide area. If you have any technical difficulty, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the resource list icon that looks like a folder at the bottom of your screen. This program is approved for Illinois, Iowa, Nebraska, and Tennessee continuing legal education credit. Missouri and Wisconsin credit is still pending. To report your hours in Illinois, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. You may also download the certificate of attendance from the certificate widget after the completion of today's program. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you. So without further ado, let me introduce my colleague Grant Leach, who is a partner in Husch Blackwell's Omaha office. Grant is a highly adaptive attorney who focuses on international trade, export controls, trade sanctions, and anti-corruption compliance. He has extensive experience helping clients navigate complex issues related to international commerce and its associated compliance challenges. Grant?
Nitya, thank you very much for that introduction. I will be handling the bulk power foreign adversary executive order. To discuss this at a very high level, this is officially Executive Order 13-920. It was published on May 1st, 2020, exactly 2 weeks ago. That link in the PowerPoint presentation will not work if you try and click on it out of this webinar, but that link should be in the folder with the presentation materials at the bottom of your screen. And another addition to that folder is an FAQ that the Department of Energy literally just put out, which is not going to be reflected in the slideshow, but I will try and discuss it as we go through these slides. We're also going to email a link to that FAQ in the materials that go out to all of the webinar participants. But the gist of this executive order is that it authorizes the U.S. Energy Secretary to prohibit the U.S. bulk power electrical system from acquiring or installing or potentially from transferring any equipment that is sourced from foreign adversaries. The idea behind this executive order is that we're very mindful of the risk of cyber attacks to the U.S. Critical infrastructure, to the U.S. power grid. And in order to prevent those sort of cyber attacks, we're looking to restrict certain foreign origin equipment and components that might come with built-in vulnerabilities or might somehow make our power grid susceptible to these foreign attacks. I had a couple of clients discussing this order with me, and they were skeptical whether this is a legitimate concern or whether this executive order was just part of an ongoing trade dispute with China, something for leverage in tariff negotiations. This is actually part of a broader initiative that the Trump administration is taking on with regards to national security, really broadening that definition of national security, not just to include defense concerns, but also the digital economy, the power grid, data servers, a much wider concept of national security. In the executive order itself, they cite this idea that foreign adversaries are increasingly creating and exploiting vulnerabilities in the U.S. bulk power system. The executive order notes that if any of these cyber attacks were ever successful, that it would cause serious harm to the U.S. economy, human health and safety, and our defense capabilities. On the public record, we have a Senate hearing where the Director of National Intelligence basically testified that they believe both Russia and China are currently capable of launching cyber attacks to disrupt critical U.S. energy infrastructure. The FAQ that the Department of Energy just put out cites a similar attack that someone successfully implemented against Ukraine several years ago that was able to knock out their power grid for parts of the country for approximately 6 hours. So this is a real threat. This is something that we expect the Department of Energy to take seriously. And then talking about kind of this broader context, this isn't the only initiative the Trump administration is doing to expand this concept of national security. For example, the 2019 Defense Act now prohibits federal agencies from procuring certain hardware and software from Chinese suppliers Huawei and ZTE because we believe that those present national security concerns if deployed in the right environment. There was a similar executive order that President Trump issued in May of 2019. That order contains a lot of the same phrases in this bulk power order, except it's directed at the information and communications technology services sector. And basically that also gives the Commerce Secretary authority to block or unwind certain transactions in the ICTS sector that involve equipment, software, or services sourced from foreign adversaries. So that term shows up in both of these executive orders, even though they are directed at different federal agencies. And then we've also seen the CFIUS process has been revamped. We continue to be very sensitive about foreign actors coming in and purchasing U.S. businesses that would either give them some sort of influence or visibility to critical sectors of the U.S. economy, or somehow that could affect national security or criminal infrastructure. So it's not just this executive order. This is part of a broader trend where the Trump administration is being more and more skeptical of what role some of these foreign countries play in our power grid and in these other critical aspects of the U.S. economy. The order itself, it gives the U.S. Energy Secretary the authority to prohibit any acquisition, importation, transfer, or installation of any bulk power system electric equipment. And we put that in red text in bold because that definition, how that's defined by the Secretary, will be very important. And the Energy Secretary is authorized to prohibit any of those activities which it collectively defines as a transaction if that transaction meets the following criteria. It has to have property in which a foreign country or a foreign national has an interest, which could include a contractual interest. That transaction, whether it's an acquisition, importation, transfer, or installation, has to be initiated after May 1st, 2020. And then it has to involve equipment that is designed, developed, manufactured, or supplied by persons who are owned by, controlled by, or otherwise subject to the jurisdiction of a foreign adversary. So that term, foreign adversary, is also going to be very important in figuring out how this executive order is going to be administered. So that's why we put it in red, bold text. And then the transaction has to pose a certain specified threat to U.S. national security. And there are 3 types of specified threats the executive order identifies that could trigger this blocking authority for the Energy Secretary. It can either pose an undue risk, sabotage to, or subversion of the design, integrity, manufacturing, production, distribution, installation, operation, or maintenance of the U.S. bulk power system. It could pose an undue risk of catastrophic effects on the security or resiliency of U.S. critical infrastructure or the U.S. economy, or it could otherwise pose an unacceptable risk to U.S. national security or the security and safety of U.S. persons. The order doesn't give a lot of detail in explaining what the difference is between an undue risk in those first 2 bullet points or an unacceptable risk under the 3rd bullet point, but these are the standards that it uses, and for what it's worth, those are the same standards set out in that ICTS executive order that was directed to the Commerce Department. So the key terms in this executive order are the bulk power system, which is defined as facilities and control systems necessary for operating an interconnected electrical energy transmission network or any portion thereof, and then also electric energy from generation facilities needed to maintain transmission reliability. So this definition is not just the grid itself, but would also include generation facilities that are connected to and supply power to that grid. In the FAQ that the DOE just put out, they affirm that, talking that this also includes generation facilities that are supplying to the grid. It expressly includes transmission lines rated at 69,000 volts or more, but it does not include facilities that are only used in the local distribution of electric energy. And then this term, bulk power system electrical equipment, lays out this litany of different types of equipment that are either used in bulk power system substations, control rooms, or power generating stations. I wanted to highlight 3 of these here. Obviously, control rooms, that would be the kind of thing where you could expect a foreign adversary who would somehow be looking to exploit a vulnerability or build in a vulnerability into any control components that they supplied to the bulk power system. But also, one of the items here is metering equipment. And I think that gets at a concern. It might not be necessary for a foreign adversary to build in one of these vulnerabilities just into a control component. It might be enough for them to build these vulnerabilities into just individual metering equipment. If they can remotely access some of these metering devices and switch them so that they start spitting out bad data, that might be enough to kind of start some other protocols in the control system that would force an automated shutdown of different equipment within the grid. So it's not just the control rooms. It could also be just metering equipment connected at different points in the power grid. And then also wanted to underline the term generation turbines just to, again, point out that this can also include generation equipment. This note at the very bottom of the slide, there is a carve-out in the order saying that it does not apply to equipment that has broader application of use beyond the bulk power system. So if you have laptops that your employees might be using that are purchased from a foreign manufacturer, that laptop itself has broader application outside of the bulk power system. This executive order is not going to require you to go in and replace all of your foreign origin laptops with U.S. origin laptops. It's focused on stuff that is bulk power system electrical equipment. And then the order's definition of a foreign adversary That is any foreign government or foreign non-government person engaged in a long-term pattern or serious instances of conduct significantly adverse to the national security of the United States or its allies, or the security and safety of the United States persons. The order itself does not specifically identify who any of these foreign adversaries are. It's widely speculated that this will be China or perhaps individual Chinese companies. One thing about this definition and the way it's set up is the Secretary has the discretion to either identify an entire foreign government as a foreign adversary, or they can just identify individual foreign companies. And the distinction there is that because this order gives the Energy Secretary to require the blocking of any transaction with either a foreign adversary or someone who's just subject to the jurisdiction of a foreign adversary, if the Energy Secretary did choose to designate China as an entire government as a foreign adversary, that would mean any other Chinese company that is someone subject to China's jurisdiction would also be subject to the order's blocking prohibitions potentially. So it will be interesting to see how the Energy Secretary decides to designate people or countries as foreign adversaries. The executive order requires the Energy Secretary to take certain actions as soon as practically possible. We don't know how soon as practically possible is supposed to be. There's a separate section that requires the Secretary to issue certain regulations within 150 days. So we're hoping that as soon as practically possible is going to be sooner than 150 days. However, the order also requires the Secretary to consult with at least 5 other federal agencies before taking these actions, so it might be a while. But whatever that time frame is, as soon as practically possible, the Energy Secretary is required to identify this kind of bulk power system, electrical equipment that is sourced through foreign adversaries, which also presents one of these specified risks to U.S. national security. And then the Secretary is also required to develop recommendations on ways to identify, isolate, monitor, or replace that type of equipment. On a 150-day timeline, which will expire on Monday, September 28th, 2020. So by that date, the executive order requires the Energy Secretary to publish implementing regulations to implement the order. The order gives the Secretary the authority, but not a requirement to take any of these following actions, which could be specifically identifying foreign adversaries, identifying particular countries or equipment types that warrant particular scrutiny, and then establishing procedures for licensing transactions that would otherwise be prohibited by the order. The way this order is drafted, the Secretary is not required to give that degree of guidance, but if they want to, they're authorized to. And based on what we've seen from a press statement that the Energy Secretary put out, from the FAQ document that they just put out a day ago, it does seem like the Secretary is interested in trying to provide the regulated community with some practical guidance here. So hopefully, even though it's not outright required, all of this guidance will work its way into those forthcoming regulations. Another authorization that the executive order makes is it authorizes the Secretary to establish certain pre-qualification criteria and put together a list of pre-qualified equipment and pre-qualified vendors. If the Secretary chooses to make that list, and if equipment or vendors wind up on that list, then they're exempt from the order, and persons know that they can procure that equipment, install it in their projects, and they don't have to worry about having those transactions blocked. This is discretionary. This doesn't come with any sort of timeline, so it doesn't necessarily have to be within 150 days. It certainly doesn't have to be as soon as practically possible, but it's something that the Secretary is authorized to do And in the FAQ that they just put out recently, they indicated that they do want to put together this kind of pre-qualification guidance. So hopefully we will see that coming down the pipeline here. As you can tell, there is a lot of ambiguity in this executive order. We're not going to know exactly how it's going to be enforced or interpreted until these regulations and until further guidance comes out from the Secretary. So these next couple of slides, I just wanted to point out a couple of models of similar regulatory schemes that the Energy Secretary might look to follow when it implements these regulations. These are just models. This is entirely speculative on my part. I have no idea what the Energy Secretary is ultimately going to do, but I thought it might be helpful to consider how other federal agencies have dealt with similar directives. The first one is that Commerce Department ICTS order that I talked about in one of the very first slides. So this was directing the Commerce Department to put out regulations to prohibit people in that information community technology services sector from using products, services, and software sourced from foreign adversaries that could threaten national security. That order was issued on May 15th, 2019. And like this bulk power order, it required the Commerce Secretary to impose their own regulations within 150 days. Well, Commerce really drug their feet. They didn't put out anything until 44 days past the deadline. So they were supposed to have something within 150 days. It was supposed to be regulations. Instead, 194 days later, what they put out was a proposed rule. This proposed rule came with a 30-day comment period. That deadline was going to be, I believe, something like December 27th, right over everyone's Christmas holiday. So the Commerce Department wound up extending that comment period for another 30 days. That comment period expired, but the Secretary is still reviewing all the comments. No rule has taken effect yet. All we have is a draft of a proposed rule, which is the Commerce Secretary's proposal for enforcing this executive order. And the ICTS order was, as I said, drafted very similarly to this bulk power order. It gave the Commerce Secretary a lot of authority to provide kind of bright line guidance to specify and specifically identify which foreign countries or foreign companies are foreign adversaries, to specify which types of services are expressly prohibited, what type of hardware is expressly prohibited. They also had authority to kind of put together a similar pre-approved, pre-qualified list. Despite all of those authorizations, the Commerce Department, their proposed rule basically said, we're going to call this on a case-by-case basis. They didn't give any real proactive guidance. They just put the community, the regulated community, on notice and said, we're aware of this threat. We have other government agencies might report concerning transactions to us. We will accept reports of concerning transactions from the general public, and they're just going to review them on a case-by-case basis. So there's nothing that is currently in this current proposed rule that would really give people in the ICTS sector any sort of practical guidance for when they're acquiring software and services that they might be required to divest, or somehow the Secretary could come in and block it. Thankfully, based on the approach that we've seen from the Department of Energy over the past couple of days, it looks like the Department of Energy really wants to give out practical guidance in enforcing this executive order. So hopefully we're not going to see something similar to the Commerce Department's approach with their own ICTS order. Another example here is the CFIUS review process. So this is how we restrict foreign buyers from purchasing U.S. businesses that somehow affect U.S. national security or U.S. critical infrastructure. The CFIUS regulations, the way they work is there is a short list of sensitive investments related to either what's considered to be critical technologies, critical infrastructure, or sensitive personal data. If a foreign person is making an investment into any one of those industries, there will be a mandatory notice filing. And then if a foreign company is making an investment that might not show up in that short list, but that is maybe in a gray area or that could potentially affect national security, that foreign investor has the option to make a voluntary CFIUS notice filing. And then after that foreign investor makes the voluntary filing, the CFIUS committee will review the filing. If they are comfortable allowing that transaction to proceed, they will issue basically a safe harbor protection. What that does is that protects the foreign investor from the risk that CFIUS might later come back and force them to divest their investment. Another aspect of the CFIUS regulations is that they define accepted foreign investors and accepted foreign states. Currently, CFIUS has designated the countries of Australia, Canada, and the United Kingdom the accepted foreign states. What that means is that we're much more friendly to investors from those countries purchasing businesses that somehow implicate U.S. national security or U.S. critical infrastructure. It doesn't mean that they're going to be able to do it without the CFIUS filing every time, but there will be some times when the CFIUS filing isn't required, and if they do elect to file the CFIUS filing, it will be reviewed. That process would hopefully process a little more easily. So this is another example of something the Energy Secretary could try and adopt as far as trying to give bright line guidance for what sort of transactions are going to require pre-approval from the Energy Secretary, or what sort of transactions might be in a gray area where someone could ask for this kind of approval, ask for this kind of safe harbor protection. This type of scheme is authorized under the executive order, but we don't know if the Secretary would roll this out. As I said, this is complete speculation on my part. And then the last example I wanted to give here is the NNSA licensing policy for nuclear technology exports. This is when you have information related to the maintenance or operation of nuclear power plant, other nuclear technology. We have restrictions on exporting that type of information outside of the U.S. The NNSA is a division of the Department of Energy, and what they've done is they have a general authorization that says if a country is in any of this list of 50 authorized countries on Appendix A, you don't have to apply for a license. You can just share the information with one of those 50 countries. If a country is not on that list, then you have to go to the NNSA and seek a specific license. Either way, whether your recipient is on the general authorization list or whether you receive a specific authorization, the NNSA requires a lot of follow-up reporting. So it's not enough just to export your stuff. You also have to send follow-up notices to the NNSA to report those transactions, whether they're covered under the general authorization or a specific authorization. I bring this up only because the Department of Energy, since they have these follow-up requirements in their NNSA licensing program, it's possible that whatever regulations they implement to enforce this bulk power order might also require some of that follow-up reporting for people using some of this equipment. There are several unanswered questions that come up out of this order. This first one is, how will the Energy Secretary apply rules of origin when interpreting the term bulk power system electric equipment? And this was actually addressed in the DOE's FAQ. They don't know yet. They're going to discuss this with stakeholders and see, but the question is, if you have a piece of equipment that is manufactured mostly in the U.S., but has some imported parts from a potential foreign adversary, is that equipment still going to be subject to this executive order? And the DOE does not know that they're going to be reviewing that. They gave similar guidance talking about what happens to a U.S. subsidiary of a foreign parent company, whether equipment that they produce is potentially foreign adversary equipment. The Department of Energy is going to look into that. They do not know, but they're going to discuss that with affected stakeholders and hopefully make a determination, give us some guidance on that point. Another question is, with the order having an effective date of May 1st, 2020, how far back is the Secretary going to go in enforcing this order, especially because we don't know what the requirements are right now. What the Secretary said in its guidance is they clarified that for the time being, this is not a rip and replace order, that for anyone to start trying to pull out equipment right now would be premature. They have to identify what this nexus is between the foreign adversary and the national security risk. It's still unclear how they're going to go about enforcing this effective date, which did take effect the day the executive order was issued. So this will just be something to watch going forward. As I just mentioned with the rip and replace statement in the FAQ, there is a section in the executive order that requires the Energy Secretary to issue recommendations for replacement of equipment. So that's drawn a lot of attention, trying to figure out if people are going to have to replace equipment. It's worth noting that it's not a requirement to replace equipment. It's just simply recommendations for replacement of equipment. So we'll have to see how that concept is worked into these regulations when they are published. And then this other note, how will the Energy Secretary apply to the order's restrictions on transfers of prohibited bulk power electrical equipment? That is one of those transactions that is listed as being subject to this order, a transfer. So that raises the question, what happens if you have a power project where you've installed some of this equipment that is later designated as being foreign adversary bulk power equipment? And if this order prohibits any transfer of that equipment, what happens if there's a change of ownership in your project? How would these transfer restrictions potentially apply to that sort of a transaction? We don't know. This is going to be another thing to keep an eye on as these regulations are drafted. That concludes my summary of the bulk power executive order. We've allotted for time at the end of the presentation for questions and answers, but for now, I'm going to transition to Nithya. She already gave herself an introduction at the start of the presentation, and she's going to cover the 232 transformer investigation. So Nithya, please take it away.
Thank you very much, Grant, and thank you, everyone. To start out, the transformer investigation, or more precisely, the initiation of the investigation on imports of laminations and wound cores for use in transformers, electrical transformers, and transformer regulators was announced on May 4th, 2020, so it was last Monday. The products covered by this new investigation are laminations for stacked cores and round cores for incorporation into specific types of transformers, and there's 3 of them that are articulated in the announcement. These are transformers, electrical transformers, transformer regulators, but these components should also be made of grain-oriented electrical steel. So that kind of fine-tunes the scope of this 232 investigation. What this investigation is going to do, it's going to examine imports from all countries, and it's not limited in scope to exports from particular countries. This is a worldwide investigation. And any limitation or narrowing of the scope of the application of any ultimate duties will be announced at the end of the investigation. What's unique about the transformers or lamination and round cores investigation is that it's a spin-off from the 2018 Section 232 tariffs on steel and aluminum. And because these laminated and stacked cores are made of steel, it's being treated as a derivative product of steel and is therefore being examined under the authority to examine derivative products. we'll get into kind of some of the legal implications of that going forward. Now, just as a refresher, why are Section 232 actions unique? Well, they're government-instituted trade remedies, but they differ from what are traditional trade remedies, such as anti-dumping and countervailing duties, as well as safeguard remedies, because there's no required showing of injury to a U.S. industry. There's no required showing of a trade-related unfairness. It is a mostly self-initiated process by the U.S. government, which the steel investigation in 2017 and 2018 was self-initiated. And similarly, this investigation on the laminated and round cores for transformers is also self-initiated. And the other thing is it has a lot of unilateral action by the government, and the procedures are a little bit confusing. So, and the important thing is these are duties over and above other traditional trade remedy duties. And the reason I bring up AD and CVD in this context is that over the course of the last 20 to 25 years, grain-oriented electrical steel has been subject to numerous anti-dumping and countervailing duties, kind of from various countries. Right now, there's no existing anti-dumping or countervailing duty order. But one of the key things to keep in mind is that the domestic industry is going to be looking at this investigation very closely. And if this 232 investigation on transformers is a little bit slow in its process, you can almost guarantee by the end of this year that there's going to be another round of investigations on grain-oriented electrical steel, because it's almost like you can attack a problem from two sides. The first option is to do this more overarching, kind of a less burdensome on the domestic industry action, which is the 232, because the government does all the work for you. If that's not moving at a pace that they like, then the option is a traditional trade remedy like AD/CVD, which means that burden of proving and bringing the case is on the domestic industry. And that is just something to keep in mind as folks on this call monitor this case. And it's an important aspect to kind of communicate with your supply chain or your information chain, because you never know when industry information can help strategize and plan for your kind of your business activities. Now, in a normal situation, Section 232 is under a specific area of the trade statute. It's under 19 U.S.C. 1862. And it specifically directs Commerce to submit a report to the President advising whether any article, and I quote, is being imported into the United States in such quantities or under such circumstances as to threaten to impair the national security. And that's a key term, threaten to impair the national security. So you would think that that would require a correlation. However, with the steel investigations, it was found that there, in fact, the Defense Department actually stated that imports of steel were not threatening the national security. However, as we all know, the Commerce Department found that there was, and then the President instituted tariffs on steel and aluminum. So while that is a provision in the statute, it's very loosely defined, and it gives a significant amount of authority to the agency conducting the investigation. Just a little bit of history is that prior to 2017, that is between 1962 and 2018, there were only 26 Section 232 investigations. Out of those, only 6 actually had the President taking any action. And the last one before 2018, the last time Section 232 was used was 1986. So, going back almost 30 plus years, It has been an effectively dormant statute, but has significantly revised in the last couple of years, because since the Trump administration took office in 2017, there have been 5 and now 6 232 investigations. The timeline for a 232 investigation is pretty long. It's almost a year. So once an investigation is requested in the event there was a petition, which in this case wasn't, it was self-initiated. So that pretty much becomes day one. The investigation starts, and the Commerce Department has 270 days in which to conduct its analysis. This includes a lot of steps. However, most of this investigation is done behind the scenes. There is no public record of what's happening until the decision is issued on approximately day 270. So on day 270, the Secretary of Commerce will send its report to the President. And the President has about 90 days to decide yay or nay. Is it going to go forward, or is it going to, just he doesn't agree and he's going to nix it. So if the President says, no, I'm not going to do anything, or if the Commerce makes a negative determination, then the case goes away. If it's affirmative, after the President decides after his 90 days of review, then he has 15 days to implement. And then within that, he also has to inform Congress that he plans to implement these new tariffs. Now, going through the current Section 232 investigations, this is important to put into context as to where and how the laminated and wound cores investigation could go. Now, we know Section 232 on aluminum and steel. That case was self-initiated. Commerce did the investigation in 2017. It issued its report in January of 2018, and then the President instituted tariffs on March 23rd, 2018. The second case that was in current history is the 232 on auto and auto parts. That was self-initiated in 2018, but then when Commerce submitted its report in 2019, back in February of 2019, there's still no action. So a lot of the legal thinking is that there's no longer the statutory authority to institute tariffs on on auto and auto parts. Same with uranium. They initiated in 2018, gave a report in April 2019, but after the establishment of a nuclear fuel working group, there's been no action to date. Titanium sponge, the report was given to the President in just a couple of months ago, right before we all went to work from home in February of 2020. So, but the President did announce that there will be no action taken on that. However, there's still negotiations ongoing with Japan to ensure that titanium sponge is still available for national defense and critical industries. So that leads to the two cases in 2020. The first is the laminated and wound cores, and the second one is mobile cranes, which was initiated 2 days after laminated and wound cores. So on average, whatever action is to be taken, it's not likely in 2020 because that's the investigatory period. Any action, if it is to be taken, it will be taken only in 2021 at this juncture. So what are kind of the next steps? Well, we anticipate that there will be public hearings and consultations, but the timing of that is unknown. So we're keeping a very close eye on it, and I know Husch Blackwell does regularly update on this, so we will be announcing to interested parties, and we'll make sure to reach out to everybody on this call if a comment period is announced. The Commerce does also notify or will notify the Department of Defense for its comments. And after that, when interested parties can submit comments, you want to make sure that you are expressing whether or not there is a need for this product, whether or not it's linked to national security. Now, the issue here is that the industries that are affected are the solar, nuclear, wind, coal, and natural gas industries. There is a potential kind of connection, whether it be direct or tangential, with national security because this is our nation's energy supply. So these are, you might want to start thinking, if you are interested or planning on submitting comments, how to present this information. Because while it might not be national security in a defense-related aspect, it could be for other aspects. And the other important thing to keep in mind is the Steel 232 tariffs, the ability for the president to actually institute those tariffs is currently on appeal to the Supreme Court. And that will likely not only affect how the laminated and wound cores case progresses, but it's also going to affect some derivative tariffs that were instituted on nails and other products in January of this year or early February. So regardless of what the status of the investigation is, there are some practical key actions that you should probably be taking. If you are an importer of any of these laminated or wood cores, this would be the time to ensure and confirm your tariff classifications. Look at that. Look at to see if there's any kind of variation that you can, carve out. Is this really correctly classified? And also anticipate what would happen if there are the opportunity to submit exclusions should the case go forward. And these exclusion processes have been in place for the 2018 Steel 232 tariffs, so it's very likely that it's going to be for this one as well. But there's no harm in planning for that option now so that you have some lead time to get all the information and all your ducks in a row rather than trying to scramble and do it after it's announced. So those are this is just a broad overview because the investigation is barely a week old, but we're happy to answer any questions by participants. So let me try to see if we can, I'm sorry?
Yeah. Nithya, this is Grant.
Yeah.
I see we received 3 questions in the tank right now. Mm-hmm. And it looks like these first 3 have to do with the bulk power order. The first one
Why don't you go ahead?
Is asking.
Go ahead.
Okay. The first one is asking, has it been clarified who are the foreign adversary countries? No, that has not been clarified yet. It's widely understood that it's going to involve China in some capacity. But as I said, the way that the order defines foreign adversary, it might not necessarily be an entire country. It could just be an individual foreign supplier. So we're expecting that whether it's the entire country of China, whether it's specific suppliers in China, it could also be specific agencies of the Chinese government that control state-owned enterprises in China. We don't know for sure. The order is silent on that point, but the current FAQ guidance from the Department of Energy indicates that they'll hopefully be making some sort of identification of those foreign adversaries. The next question I have here is, what about U.S. companies with China manufacturing? Will they be included in the definition of subject to the jurisdiction of China? The way the order is drafted is, if the Energy Secretary did decide to define the entire Chinese government as a foreign adversary, then that would also authorize the Energy Secretary to prohibit any acquisition of equipment sourced from a supplier that is subject to the jurisdiction of China. So assuming that you're a U.S. company that has a wholly owned foreign entity or a Chinese subsidiary that was subject to China's jurisdiction that could potentially be subject to these blocking provisions under the order, but the Department of Energy has also indicated in its FAQ guidance that it's not sure yet how it's going to apply this rule to foreign sourced components. So when you have stuff that's coming from outside of China and then undergoing further manufacturing in the U.S., the Department of Energy is looking to discuss that with the affected stakeholders before it makes a determination. So that's a long way of saying we don't know. Possibly they could qualify as foreign adversaries. The next question I have here is, if country X is designated as a foreign adversary and company Y is based in country X but actually manufactures a product of concern in a non-adversary country outside of country X, can you provide any additional guidance on this situation? So this would be a situation where, hypothetically, if China was designated as a foreign adversary and a Chinese company had a plant in, let's say, Brazil, would equipment sourced from that Brazilian plant potentially be subject to this executive order? And we don't know based on the FAQ guidance. It seems like the Department of Energy is aware that there's this ambiguity with how foreign subsidiaries located in some of these foreign countries may or may not qualify as foreign adversaries. And it seems like the Department of Energy is going to discuss this with stakeholders and hopefully provide some guidance. But for the time being, we do not know. Nithya, do you want to take this next question on the size limit? Yeah.
Sure. The question is there a size limit on the laminated steel for this investigation? Well, the answer to that is right now it's unknown, because the only thing that Commerce has indicated is that they are looking at this broad category of laminated and wound cores. All the specificity related to sizes, HTS, specific product descriptions, that's going to be only announced at the end of the investigation when the report is finalized. So unfortunately, that's going to be an unknown. However, when the comment opportunities come up, if sizes matter in the energy sector, those are the types of comments you want to consider filing for the Commerce Department's consideration. So the next question is, would this affect transformers built in Mexico? Okay, that is a very good question, because currently Mexico is exempt from Section 232 tariffs on steel. Since the laminated and wound cores case is a derivative of the 232 on steel from 2018, the likelihood of Mexico being excluded from this is very high. However, similar to the derivative tariffs on nails and fasteners and other bumper stock products that was issued in January and instituted in February of 2020, until the announcement is made, we are not sure that Mexico will continue to be excluded from any tariffs. So that's a question that it's very likely, but the answer is unknown right now. So, Grant, I think the next question is for you.
Yeah. So we're asking, is there any indication that the definitions within the bulk power order will impact or supersede existing NERC regulatory definitions? At this point, it is not clear. It's interesting that they did build off some existing NERC guidance when they used their definition of bulk power electrical system. But at this point, it's unclear. We'll have to wait and see what these regulations say when they actually come out. The next question also relates to the bulk power order. It's asking, can you see any case where Japan, Canada, or Mexico could be designated as a foreign adversary? Don't know for sure. The thing left unsaid in this order is that it seems to be targeted at China and Russia without specifically identifying China or Russia by name. The FAQ guidance the DOE has put out list to that report to Senate that specifically identified China and Russia as having potentially capabilities to launch cyber attacks on the U.S. power grid. There isn't anything in any of the resources that DOA cited to that mentioned Japan, Canada, or Mexico in any sort of an adverse light. Canada is actually one of the countries on that friendly short list for CFIUS. Granted, that's a completely different regulatory scheme, but I think that shows that we're on pretty good terms with Canada from a national security standpoint, thank goodness. It's too early to tell. I can tell you my professional opinion. I think it would be really unlikely if any of those three countries was designated as a foreign adversary. But there's also this idea that what if they are sourcing electronic components from a potential foreign adversary and incorporating those components into their equipment. In that instance, something produced in Japan, Canada, or Mexico could still be subject to this executive order if it incorporates control components or communication components sourced from a foreign adversary supplier. And then, all right, this next question is asking, regarding the bulk power systems order, does the Energy Secretary have the authority to require or enforce the replacement of equipment, or only the recommendation for replacement of equipment? That is one of those items in this order that is really unclear right now. As I mentioned, when it does talk about the guidance for replacing equipment, that is described as a recommendation. It's not described as a requirement. But since the order does have an effective date of May 1st, 2020, that does leave some people in limbo that if you installed equipment after May 1st, that if the Secretary has the authority to prohibit those transactions, it could arguably also have the transaction, at least with regards to installations taking place after May 1st, maybe the Secretary could potentially have the authority to go back and require the replacement. We don't know for sure, so that's another one of those points where we're just going to have to follow the regulations closely and see what the Secretary actually says. Nithya, I think we have one last question if we have time, and it looks like it's on the 232 investigation.
Okay. What impact would an adverse Supreme Court ruling on the validity of Section 232 for steel and aluminum have on the current investigation? When you say there's what adverse Supreme Court ruling, what that means is yes, that the president continues to have the power to institute 232 tariffs. Well, if that's the case, the case is going to go forward, and at the end of the 270-day mark, if Commerce says, okay, there is in fact a need to take some action, well, the president then has the authority within the 90-day deadline to institute additional tariffs. Now, the question is that right now, the timeline for the Supreme Court to hear the case would be in the October session. So it's not slated for kind of the docket until the October session. So by the time they rule, it would be likely spring of 2021, at which time the investigation at Commerce, as well as the 90-day window for the President to act, they're all going to kind of come together at the same time. So as an initial matter, I would say that it's now a watch and wait situation because there's no definitive answer. And so with that, I think we are at the 2 o'clock time window, and what I could say is, you know, if it's okay, Emily, I will go ahead and do our closing. If there are any questions that have remained unanswered, we will try and respond to them individually after we conclude the presentation. So thank you very much for joining us today on our program. We hope that the information we provided was helpful for you and your organization. If you have not already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs. As a reminder, this program is approved for Illinois, Iowa, Nebraska, and Tennessee CLE credit. Missouri and Wisconsin credit is still pending. A recording of the webcast will be available tomorrow for both watching and sharing. And once available, a link of the recording will be emailed to you. This concludes our webinar, and we thank you all for taking time out of your day to join us.